Good morning, everyone. Thank you for making the time to attend this event. It's really great to be able to speak directly with you, and I'd just like to extend my thanks to everyone at R3 and Veronica for facilitating the event, and to Julia. I'm well aware that there's a lot of effort involved in putting these events together. So thank you to all of those involved. I understand that the slides will be circulated following this event, or a link will be circulated. So what I don't want to do is to kind of parrot everything that is on the slides. So if I could have the next slide, please. Thank you. So, as Julia mentioned at the outset, we now have an act. The Corporate Insolvency and Governance Bill became an act at about 6 o'clock last Thursday evening, and it came into force at midnight on Friday the 26th. Now that is worth mentioning. That's fairly unique in a sense. Often acts don't come into force straight away. Sometimes there is a lag of a couple of months or so, but given the nature of what's in the act, measures were taken to ensure that it came into force as soon as possible. As you may know, the bill was introduced in the Commons on the 20th of May, though the substantive stages of the bill didn't commence until the 3rd of June, at which time the bill passed through all of its Commons stages in one day. The bill as a whole went through all of its stages in around a month. Such are the extraordinary circumstances that we find ourselves in. And I just want to, in terms of what's on the slide, in terms of what does this act achieve, or what is its purpose, and it really is to provide businesses with the flexibility and breathing space which is much needed to continue trading during this difficult time. If I could have the next slide, please. Thank you. So this is the Corporate Insolvency and Governance Act. It's an act of two halves, in a manner of speaking. There are a range of insolvency measures, which include a combination of permanent and temporary measures, and there are measures relating to corporate governance, namely provisions relating to the holding of meetings and filing requirements. It's worth my noting that both of those measures are temporary in nature. As I've just mentioned previously, some of the provisions within the bill, such as some of the insolvency provisions, are permanent measures. And as was mooted at the outset, there is an opportunity to learn more about those on the 7th of July. The driver for these measures was clearly the pandemic, but we were hearing very loudly from industry that businesses were facing a cliff edge regarding the holding of their annual general meetings. And while there was very comprehensive guidance published by the likes of ICSA and Slaughter and May, that only went so far, and it was, industry came to a view that, as I said, that could only go so far, and a legislative response really was required. With respect to filings, many of you may well know that Companies House has exercised what powers they have to extend accounts filing deadlines. As the Secretary of State said on the 28th of March, by which time 10,000 odd businesses had applied for an extension, the Secretary of State said that we will keep this situation under review and extend filing periods as necessary. And we took the view that there was, in fact, more that we could do here. Next slide, please. Thank you. I want to just talk through the the provisions with respect to annual general meetings. To some extent, the provisions have already been well rehearsed. As I mentioned previously, there is comprehensive guidance on the ICSA website, and BEIS has published guidance jointly with the FRC, which is available on the FRC's website. By the time the coronavirus hit, we were well into the AGM season, and many firms were rightly concerned about how they could hold a meeting, which they are required to do, of course, under the Companies Act, and by a certain point in time, and for many, that point in time being the end of June. There was notable concern from companies that didn't have the flexibility in their constitutions to hold a meeting other than a physical meeting. The Act therefore makes provision, and the provision is in Section 37 and Schedule 14 to the Act, to provide greater flexibility for the holding of AGMs and other meetings. The provisions apply not just to companies, but to other entities as well, such as friendly societies and charitable incorporated organisations. The flexibilities are twofold. Firstly, the flexibilities are available to certain qualifying bodies to hold AGMs by means other than a physical meeting. The important thing here is that we are not mandating or prescribing a certain way of conducting an AGM or other meeting. Companies and others are best placed to determine what works best for them and their shareholders or members. Importantly, also, as it says on the last bullet on the slides, the measures apply retrospectively from the 26th of March in the event that meetings have taken place during the time at which the coronavirus regulations kicked in with respect to restrictions around public gatherings. And the flexibilities regarding the holding of AGMs, they will apply up to the 30th of September. And we have the ability in legislation to extend the period within these flexibilities apply. So we can extend that beyond the 30th of September. But it's worth noting that the powers to extend, they expire or they sunset on the 5th of April 2021. I said that the flexibilities are twofold. Secondly, we have also extended the period within which many AGMs take place up to the end of September, and again we have the power to extend the AGM period by regulations. If I could have the next slide, please.
Nick, it's Mike Metcalf here from ICAEW, just to ask a couple of questions and talk around the AGMs for a minute. You mentioned that there's a power for ministers to be able to extend the AGM periods. Are there any plans to use that, or just for the moment you're just going to stay with the extension of pushing out AGM deadlines to 30th September 2020?
Thanks, Mike. I think what it is that what we need to do in BEIS is to keep the situation under review. I mean, at this time, clearly we can see businesses start to open up, but clearly, we are not in a business as usual situation. So what we in BEIS need to do is keep our ear to the ground, speak with the likes of yourselves, organisations such as ICSA, ICAEW, and affected businesses. We want to get a sense of what is the uptake of these flexibilities, which will therefore determine whether or not we need to extend the flexibilities beyond the 30th of September.
Okay, I mean that's great, and I think as well, it's just interesting to observe, and correct me if I'm wrong, Nick, is that quite a lot of the act, I was going to call it the bill, the act in the area of corporate governance is all about regulation-making powers, rather than doing a lot of things directly within the act. So is that all about trying to future-proof this and be able to adapt, as the situation requires, as things unfold? To extend the temporary period, or to decide on what's the right extension of deadlines and so forth, as the situation merits.
I think that's a fair observation. I think there are a number of drivers for why things are as they are. I think often when you're making legislation or developing policy and then making legislation at breakneck speed, it might not be the best thing to put all the detail on the face of the bill. So you do, so having a regulation making powers does provide one with the flexibility. I think that having the regulation making powers also gives us the space to act as and when necessary. So as you rightly said, we can extend should we need to do so. On the insolvency side of things, as I mentioned, this is a big piece of legislation. It's a big and it's complicated piece of legislation, and generally, on the corporate governance side of things, the powers on filings are exercised via regulations. The actual measures with respect to AGMs are set out on the face of the bill, and we would exercise regulations where we want to extend things. On the insolvency side of things, there is an awful lot of detail on the face of the bill. So I'll pause there.
Okay, thank you, Nick.
Nick, it's Peter. If I can throw a question in on that as well, if I may.
Of course.
You mentioned that one of the potentials there is for additional regulations to be made. One group from which we've had quite a lot of questions is unincorporated charities, who sometimes have quite large quorum requirements. It's relatively easy for two people to have a socially isolated meeting. It's more difficult if you've got a quorum of 100. I know that in Parliament, ministers said that those sort of charities should rely on the Charity Commission statement that they'll take a lenient view where the charity can't organise a required meeting. Do you think there's a possibility of any regulation being made in future as we go forward to give a more formal solution to that?
Thanks, Peter. That's a really good question. I should state at the outset that charities fall within the jurisdiction, so to speak, of the Department for Digital, Culture, Media and Sport. However, we work closely with them in developing the policy that's written into the legislation here. Peter, you rightly said or pointed to the fact that this was discussed in Parliament by, I believe it was Baroness Annally, and what was noted is that the guidance has been published by the Charity Commission, and that it has said that it will adopt a flexible approach under the current circumstances. The tricky thing here is that what we can't do, and in terms of developing this bill, what we couldn't do is provide legal certainty for every single eventuality and every entity that existed, because I think if we sought to do so, we probably would still be developing the policy now. So I think what we needed to do, as colleagues in DCMS did, is arrive at what we consider to be a proportionate approach, which is right under the circumstances, I believe. Of course, unincorporated charities aren't corporate structures, and they're not subject to the Companies Legislation or the Insolvency Act. So in terms of legislating for them in the future, I think that would be quite a tricky proposition. But in terms of, I guess, the Charity Commission kind of putting its money where its mouth is, then I think we have seen quite recently some positive steps. And I mean, by way of illustration, I understand that the Charity Commission have agreed, for example, to allow the National Trust not to hold an AGM this year at all. So I think there is, you know, I would hope that flexibility would continue.
Yes, thanks, Nick. I mean, I certainly agree the flexibility is there. It's just we've had some feedback from some people who were a bit concerned about the legalities of their situation. But as you say, I think the Charity Commission are being really flexible, which is helpful. Thank you.
Thank you, Peter. If I could have the next slide, please. Which is shareholder rights. Yeah. So in developing the proposals, we heard loud and clear that we needed to protect shareholder rights. But those we heard from also recognised that we were in unique circumstances, and therefore the temporary nature of the provisions was very much welcome. Schedule 14 protects shareholders' right to vote, but again, the way in which voting takes place is a matter for companies and others. What we've created here is a flexible framework for businesses, charitable incorporated organisations, and others to work within that framework, you know, to do what works best for them and their members. And I mentioned earlier that guidance had been produced, and this is available on the FRC's website in the COVID-19 updates section, and that includes guidance on what we and others regard as best practice. For example, we would expect companies and to engage with stakeholders prior to, during, and following meetings, including responding to shareholders' questions sent in by electronic or other means. And the guidance also suggests or recommends that companies should consider holding shareholder days later in the year, which will offer shareholders access to the board in a similar way to an AGM, which will maintain the dialogue between those shareholders who would normally attend and ask questions at an AGM.
So Nick, it's Mike Metcalf again. If I could just pose a couple of questions in relation to shareholder rights, it's very interesting. And the first is on the voting itself. So does electronic voting replace the show of hands, which is a one person, one vote system, or the poll voting, which is one share, one vote, or either, as the case may need to be?
So yeah, this is it's an interesting question. As I said before, what we've done here is provide what we consider to be a flexible framework, and companies can operate as best they see fit within that. I mean, our objective wasn't to exclude shareholders, but to give companies the ability to conduct the business that they needed to conduct without breaching the COVID regulations, and that therefore suspending the right to member participation in the combined belief that the law as it stands provided no obvious means by which companies could of themselves risk contravening one law or the other. But I think there will be some companies out there who have the wherewithal to conduct AGMs in the manner which you mentioned there, by a show of hands. That will clearly be harder for some other companies to conduct. The point about, clearly the current circumstances do create constraints on companies, and the point I was making earlier about it's really important that companies should engage with their shareholders before, during, and after the AGM. And I guess there has been some concern that actually what companies might do is cherry pick the questions that could well be the questions that are submitted ahead of the AGM. But of course, what companies can do is they can invite questions to the board, and they can respond to those questions before the general meeting, enabling and empowering shareholders to actually vote, having had that extra information. So I think I think in sum, I think that companies will just need to work closely with their shareholders to kind of determine what works best for both parties.
Okay, thank you. So I mean, I guess that's flexibility to have electronic voting over one person, one vote, the sort of show of hands type thing, and also the one share, one vote poll. But sort of related to that, you were talking about, and it's on the slide there, engaging with shareholders. So I was a little bit surprised to see that in the Act, shareholders have no right to participate in the AGM other than by voting. And I just wondered if you could explain any of the background to that. I mean, was it concerns about whether there was the technology could enable it, or why was it limited participation just to voting?
Yeah, again, another very good question. I think there are constraints around the conduct of virtual meetings. I think, in developing the policy, I think we were very mindful the fact that if AGMs were going to be held, or if they had been postponed, you would have a lot of AGMs within a truncated period, and if there were various third parties who are providing technological solutions, then that there may not be enough in a way to go round. So I think I would go back to the point I made earlier about flexibility in that should it prove necessary to restrict attendance, then I think that is within the gift of the company by virtue of the powers in the legislation. However, that is not that is not to say that that companies need to strictly abide by that in the sense that they do not have, what we have is a flexible approach here, and they might use some of the flexibilities in the Act. They might think, well, actually we don't need to exercise that. We don't need to kind of totally close the doors, so to speak. So again, I think that really is a matter for companies, and they can provide the flexibility in terms of voting as they see fit. But clearly, what they need to do is do that with respect to the regulations around social distancing and public gatherings.
Okay, thank you. Those are my answers. My two questions on that.
Thanks, Nick. That's Peter. That's really helpful. And I think I'd just make an observation on that, if I may, which is that certainly some of the feedback we've had from institutional investors in particular is that behaviours have consequences. So I think, whilst no company that is has somebody involved who is a member of any of the organisations arranging this webinar would do so, there might be a possibility that some companies might manage the questions in the way that's been suggested. But I think that would have consequences next year when investors are coming to do their voting.
I think that's absolutely spot on, Peter. This isn't a one-shot game in terms of game theory. If shareholders take the view that their rights have been trodden over by companies, then clearly there will be opportunities in the future to hold those companies to account. So I totally agree with you, Peter.
Thank you. Yeah.
Thank you. Could I move to the next slide, please? Thank you. So I'm moving on now to the second aspect of the corporate governance measures, and that is with respect to filing extensions. So I mentioned earlier that by the time the bill was introduced, Companies House had made available a facility to extend on application accounts deadlines. Now, this Act provides us with greater flexibility to extend a range of filing deadlines and without the need to apply for an extension. And as you'll see from the second bullet on this slide, the Act provides for regulations to grant an extension for filing accounts to all companies and for extensions of deadlines for confirmation statements, including event-driven filings and the registrations of charges. Now, I'm very pleased to say that the regulations were laid before Parliament on Friday afternoon, and they actually came into force on Saturday. So these flexibilities exist now. They are live. They're in force. And if you want to look at the regulations, they have a very snappy title of the company's etc. brackets filing requirements, close brackets, another brackets, temporary modifications brackets, regulations 2020. I said it was snappy, and that is statutory instrument number 65. And a quicker way of finding them will, if you Google legislation.gov.uk, you just put in the year, so put in 2020 and the SI number, which is 645, and you'll go straight to the regulations. If I could, oh, sorry.
Nick. So I mean, it's probably just it's Mike Metcalf again. It's just worth maybe confirming at this point that the regulations that came into force extend the deadlines by the same 3 months that Companies House is giving out on an individual basis. So it says now on across the board filing deadlines for all private and all public companies of 12 and 9 months respectively. Is that right?
That's right. That's right, Mike.
Yep. Okay. That's very welcome. Sort of to put it onto a permanent everybody footing rather than the sort of the stopgap measure with Companies House having to give them out to everybody individually. So that's great. Thank you.
Yeah. And I should note that, I mean, with respect to Companies House, I mean, what they did have in place was, I think, a fairly neat solution in that one could apply for the application or within less than 15 minutes or so. But clearly, given current circumstances, I'm sure there are better things that companies could be doing in keeping their business alive. And so to have a blanket extension is the right thing to do in the circumstances. If I could have the next slide, please. Yeah, I'm, as I said at the beginning, the slides will be circulated, so I'm not going to parrot what is on here, but I would just like to reiterate that the power to extend filing deadlines is a temporary one and will only be available up to and including the 5th of April 2021. So if we could just move on, please.
Yeah. Okay. Well, Nick, so does Mike Metcalf again. So just come in. So I mean, I think just on filing, it's probably worth noting that the filing deadline in the Companies Act affects more than just filing. So it's the key date for a number of other things as well. So actually, that flows. The extension flows on to all of those. So the same extension flows on to the timing requirement to circulate accounts to shareholders. And sort of as noted on the slide, for PLCs to lay them before members in general meeting. So that's all very helpful, and I think all works together with for listed companies, for example, the FCA's extension to capital markets deadlines for producing accounts. So overall, the governance arrangements here fit with that, because if companies are going to take advantage of the FCA's more time available to get the accounts out into the capital markets, they also need more time. They need to be able to push forward their AGMs and the circulation of the accounts and all of those things as well. So it all fits very well with the SCA's earlier moves. So it's great. Thank you very much.
Great. No, thank you. That's good to know. One of the things that we sought to do was to try and dovetail the filings provisions with the AGMs provisions, given the nature of AGMs, accounts meetings, the filing of accounts. That they needed to dovetail, and we think we've achieved that. So that's good to hear.
Thank you.
Thank you, Slide Master, for moving us on to what is the last slide in my presentation, which really is around the scope of the measures, and they will be available to the more than 4 million companies registered at Companies House, and there are other entities which are required to file documents with Companies House. So these measures apply also to entities such as limited liability partnerships, LPs, overseas companies, etc. And that is set out. I think it's on the face of the Act itself, and I believe in the regulations as well. So I shall pass back to the chair and just thank the guides for some very interesting questions.
Brilliant, thanks, Nick. Just check that you can hear me because I can't see myself back up there.
Yeah, I can hear you just fine.
Brilliant, thank you. Thanks very much. Just get the webcam back. Thank you. Just before we give Peter and Mike a few more minutes to mull over other questions that they might want to ask or that they've still got sort of burning in their back pocket, we've had some really good questions through from the audience. So Abby Dolan has asked, are deadlines for filing retrospective or from the date the Act was passed? So Nick, can you shed some light on that?
Very happy to. Thanks, Abby, for the question. So the filing extensions will apply at the point the regulations came into force. However, the accounts filing deadline is retrospective, and Paul Smith may well want to provide a bit more detail there. Paul?
Yeah, that's fine. So for public companies only, the accounts filing deadline extension is retrospective, and that's so that the flexibilities around the holding of AGMs can be matched with flexibilities for the filing of accounts, for the holding of the accounts meeting, as Mike mentioned earlier, and for the circulation of the accounts to shareholders. So for companies that public companies that had an accounts filing deadline on or after the 26th of March, up to the point the regulations come into force, all of their deadlines are moved forward to the 30th of September.
Thank you, that's brilliant. Next question from Alan Clark. Could you explain the work you anticipate a monitor will undertake in forming a view if a CVA will be approved before agreeing to act as a monitor?
So I am not even going to try and answer this, and the reason why it relates to I believe it's the insolvency provisions and specifically around the moratorium. So Alan, I think thank you for joining us, but do make sure that you're here this time next week. I think it is for the insolvency service webinar.
Perfect. So that's on the 7th of July, Alan. We'll be able to cover that one off. So Mike Robinson asks, my organisation is incorporated by Royal Charter, and I intend to ask the board to agree to hold the AGM virtually. We aren't covered by this Act. Would you advise telling the Charity Commission in advance?
Again, I'm, as I said during my presentation, you know, my remit is around companies and not charities, and I'm not very familiar with the workings of either charities or the Charity Commission. David Leach may well be able to add something to this. If David can, that would be great. If David isn't able to, then what I would recommend that Mike does is contact colleagues in the in DCMS and seek their advice. But I'd be interested to see what David has to say.
Hi, Mike. Thanks for the question. I don't think I've really got a lot to add to what Nick said. You know, I mean, clearly our imperative was, given the nature of our department, was to seek to assist companies. We took on board other types of organisation like mutuals, charitable, incorporated organisations. We've referred already to the flexibilities which the Charity Commission are obviously minded to offer. So I think my general advice would be that if you or the body with which you're involved want to seek flexibilities, then certainly it does make sense to contact the Charity Commission up front and discuss matters with them.
I'd add to that just quickly, if I may. I think if you're a Royal Charter body that is a charity, then absolutely the Charity Commission is the right answer. If you're a Royal Charter body but you're not a charity, then you can either do it on your own recognizances, or you can refer to Companies House if you're registering with them. But I think generally the Charity Commission is the right place to go for that.
That's brilliant. Thanks to both of you. We've got a question from Michael Illingworth on accountability. So he's asked, who is responsible for ensuring that the changes in the Act on governance are properly and fairly implemented?
That's a very good question. I think with respect to the AGM provisions, I think it will be, thinking in practice, I think it will be very difficult in a way to kind of to regulate that, so we know exactly what is happening in each of the hundreds of these meetings that will be taking place over the coming months, not just in companies, but all other businesses and entities within scope of the bill. I think certainly this is going to be a learning experience for many. And I know that the FRC is conducting a piece of work over the summer in terms of looking at best practice regarding AGMs, so that is available for the future. But the department, so BEIS, we have put out guidance around what we consider to be best practice. We hope companies act in the spirit of that. Clearly, there are usual mechanisms for if, for example, shareholders consider that, for sake of argument, that their rights have been trampled all over and that they haven't been able to hold the board accountable to the extent that they would wish, then I think clearly, there are existing routes and mechanisms for shareholders to hold boards to account. So I would pause there, and others on the panel and my colleagues may wish to add to that.
So it's Mike Metcalf here. So I think that's quite a really interesting question from a more general point of view than just enforcement of these particular company law provisions, if you can call it that. Because I think there might be a kind of a wider question of who enforces, monitors and enforces company law more generally. And I think that goes to some of the things that are thought about in terms of the replacement of the FRC with the new regulator ARGA proposed by Sir John Kingman's review, which I think when you look at the objectives of ARGA that's set there, which are extremely ambitious, it's conceived as more than just the FRC at the moment. It's something of a regulator of corporate behaviour, and if you look at all the things like effectively they'd be able to do something that's the equivalent of the old DTI inspectors regime, or they can do one, equivalent of FSMA 166 skilled persons reports. So actually, I think it touches on that wider issue, and it's going to be really interesting as you take forward. I don't know when you'll be able to do that with the current circumstances diverting all your attention. When you take forward the Kingman and Bryden reviews, it'd be really interesting to see what we're doing there in terms of where ARGA will be pitched in terms of exactly the level of its and its powers, because that's important. Its powers to try to enforce what parts of company law.
Mike, I think you're right to raise the wider landscape, and this was in fact something that came up during, as you probably know, during the passage of the bill, and I think the opposition. So I think Lord Stevenson tabled a few amendments which effectively asked, what progress are you making in reforming audit and changing the FRC to ARGA. You cited also the reviews by the likes of Sir John Kingman, Donald Bryden, and then of course there was a CMA review as well. An awful lot of reviews in this space. What I can say is clearly at this time, my department has been very much focused on addressing the challenges presented by COVID-19. But work has been ticking on, including with respect to audit reform, and my understanding is that there are plans afoot to publish some kind of form of government response shortly. So hopefully that will give you a bit of flavour of what's to come. But I can't give you an exact date. It doesn't fall within my area of responsibility, but you're certainly right to mention that.
Okay, thank you. I mean, I think it'd be very interesting to see exactly how ARGA is pitched, because it's more than just an audit or accounting regulator. It's conceived as something about almost a regulator of corporate behaviour. So it'll be very interesting to see exactly what its remit is and the powers that match that. So look forward to that in the future. But I think we all understand that will be when time and attention is available, when current exigency is over. Thank you.
It's Peter, if I can just throw a thought in on that as well, which is that for me, the people who are ultimately responsible for making sure this all works properly are the directors. They've got statutory duties to do so, and their shareholders have got legal rights to take action against those directors if they are, as we were talking about earlier, Nick, if they do misbehave in any way as far as these requirements are concerned. Yeah, absolutely. I think it will be for the regulator, and hopefully ARGA will have the powers to do that, to take action against people, more effective action against people who do choose to do that. But fundamentally, it's for me, it's down to the directors. The other point I'd make on this is that there is guidance out there. The Institute published guidance with sort of reviewed by the department, for which we're very grateful. We'll be doing another lot of guidance to follow up on the new Act, which hopefully will be published fairly shortly. So that there's plenty of information out there to help directors navigate their way through some of these issues.
Perfect. Really nice range of answers. We've had quite a few questions on how shareholders will be able to ask questions. So I'm just going to pick one of the questions from Tiziana Capobianchi-Thomas. Hope I got that right. In terms of holding an electronic AGM and the participation from shareholders, is it acceptable to ask the shareholders to submit questions before the AGM and select a sample of the questions and answer the sample. And just sort of feeding in a part of a question from Kate Anthony Wilkinson on the same topic. Does does the company need to share the entire Q&A with everyone, or can they pick and choose? Basically, can they cherry pick, Nick?
This is one which I'll pass over to David, because I know David worked very closely with Peter and others in terms of looking at the guidance that was produced, and if memory serves, I think this is one of the things that I think the guidance captures. So if I could pass over to David to respond.
Thank you, Nick, and thanks for the questioners. I won't attempt to repeat their names. Well, I think the starting point really is just to go back to what Nick was saying earlier. You know, what you see in the Act is what you get. It's not prescriptive. We have issued some guidance, and that's available on the FRC website around what sort of expectations of behaviour. But I think what I would say is that I would positively encourage companies to afford members the opportunity to raise questions prior to the meetings, because clearly the answers to these questions inform the decisions that that shareholders make in terms of their voting. So you know, I think we're not going to prescribe anything, but that's something I would certainly encourage. And I think to maximise its value, I think it makes absolute sense to make that exchange of information a sort of open forum, so that it's not exclusive to the person or to the member who has asked the question, but the answer is known and visible to all, because clearly there will be other people who would have been minded to ask the same question, perhaps. I think, again, so just going back to what Nick was saying earlier, I think we certainly wouldn't encourage companies just to use the opportunity to cherry pick and answer the questions that are either easy or that they would like to answer, and avoid those that they find more difficult or don't want to answer. And as Peter and Nick have already said, that there are mechanisms of accountability that exist, which will, I think, we'll see that practice come home to roost in the future. So, I think we would certainly encourage, as I say, companies to be open and non-selective about the manner in which they invite and answer questions prior to meetings.
So throw a few practical points on there, if I may, from sort of being a registrar in the past and sort of looking after company meetings. I think it all depends on the volume of questions you've got. I think if you get questions in advance, that can be enormously helpful, because as I'm sure Nick will agree this morning, it's much easier to have questions in advance that you can prepare a detailed written response to, than to be answering them on the fly, like I'm afraid we made him do. So actually, I think you get a better quality of answer if you've got that question in advance. And companies can then post those answers on their website and so on and so on. So I think that's enormously helpful. I think shareholders have got a right to ask questions at general meetings. And again, it's what's reasonable for me. If you have got 10 minutes of shareholder questions and you only allowed 10 minutes of shareholder questions, and there are other shareholders who want to ask questions, I think you've truncated that debate unreasonably. If you've gone on for an hour or more, and there are relatively few people still wanting to ask questions, then clearly you haven't. I think it's up to the company, it's up to the chair with their responsibility for the good order of the meeting to ensure that a reasonable amount of time is given to questions. And I always think in a physical meeting you can take the sense of the meeting. because you rapidly get a picture of whether people are voting with their feet in terms of leaving the meeting room if a particular shareholder or group of shareholders have gone on too long about a particular issue. So I think you have to be careful how you manage that. The final thing I'd say on that is I think that one technique, which some people call cherry picking, personally I don't, which I think works extremely well, is grouping questions. So if you know that you've got half a dozen shareholder questions on a particular aspect of your business, then I think it's very reasonable to group those questions together, for the chair then to try and come up with an answer which covers all the points raised in those questions and actually discusses that topic in a bit more detail. I think that's much more helpful than taking the first question on that topic at, say, 11 o'clock and the next question on that topic at 11:25 and another one at 11:35. It makes for a more logical discussion.
Thanks, Peter. It's Mike. If I could just come in at this point on this as well, because I think this touches on the sort of wider question, which we've seen a little bit of in the letters pages and articles in the FT around whether or not the virtual AGM is kind of the future, where we've seen kind of views for and against on all the sorts of things that you've talked about. And actually, I think quite an interesting perspective was brought to it by a letter to the FT by Guy Jubb, who you'll probably remember as the former head of governance. I think he was at Standard Life. He's now professor at Edinburgh, University of Edinburgh Business School, and he was kind of in favour of, as I read his letter, AGMs as a forum for shareholders to attend and speak, in particular for institutional shareholders to fulfil their stewardship responsibilities to the ultimate investors. But he was raising the issue that actually, those institutional investors have been conspicuous by their absence in the past, and actually, as well as thinking about what's the right forum or format of a meeting, actually, how does that change to get the institutional investors to use the occasion in whichever way it is arranged much better? So I think there's a couple of points there on that. Very interesting topic.
Thanks, Mike. With just 5 minutes left of this webinar, I want to come back to Peter and Mike in that order for a final question from them. I know they had a lot of burning questions for Nick, partly because we've still got some questions from the audience, but they are some very, very detailed questions, which would easily take up the rest of the time. But I just want to reassure the audience that the BEIS team have very kindly offered to look at those remaining questions and produce a response. So we will be following up. You'll get a follow-up email with a link to this webinar to watch it back recorded, but also the BEIS team have offered to take a look at those questions that are remaining. So those questions will come under the nose of the BEIS team. Don't worry, audience. But if I can come to Peter and then Mike for a briefer final question as they can manage with our last 4 minutes. Thank you.
Yeah, thanks, Julia. Brief. Okay, I mean, I suppose where I would like to just leave it, if I may, Nick, is where do you think we're going to go next with this? Are you happy that the measures that you've put in place in this Act will see us through for the rest of the period, or are there other measures in the corporate governance sphere that you're considering that you haven't implemented yet, but that you will be looking to do so in the future? And if so, what sort of things have you in mind?
A very short question, but I think the answer could well be quite long. But I will be brief because I know Mike will have a question as well. This is a really interesting question about where things might go on AGMs, and I think the current period has really, for better or for worse, has kind of acted as a catalyst for change. Companies and shareholders, different expectations, different modes of working, and it will be really interesting. I'm really interested to see how people adapt under the current circumstances. But on a purely personal reflection here, that while, I mean, I like working in teams, etc. But you know, for me personally, it doesn't replace being in the office, seeing the whites of people's eyes, and actually, this in a way is, you know, there is no substitute in my personal opinion for kind of getting out there, seeing the whites of people's eyes, holding people to account. There's a very different feel to that. So it seems to me that, you know, that people will adapt as necessary. They will do what works for them. One might imagine that you get a lot more of a sense of hybrid meetings, a mixture of the technological and the physical, just to enable, for example, we've got a country that was increasingly IT literate, but also, you know, which might suggest that actually people are quite happy to stay at home. But actually people, as you get older, you know, we're finding a more able and mobile society. So people do want to travel, people do want to get out. And so I think that militates towards, you know, as I said, kind of more of a hybrid sense of AGM. But it's going to be really interesting to see how the next few months play out.
Okay, so final question from me, from Mike, just to take it off the technicalities of it and the strategic issues. Just Nick, any reflections on working on an emergency bill?
Well, so don't do it, number one. Normally, I've worked on a few bills, whether energy and all sorts of better regulation bills and things like that. Normally, it takes about 9 months or so to get a bill through the House. It'll take you 6 months to get a bill drafted. We got a bill drafted, a complex bill, in about 6 weeks. This is a massive collaborative effort. Policy people in BEIS, in the Insolvency Service, a mountain of lawyers, comms people, Parliamentary Council, colleagues in DCMS, Treasury, a massive operation. About, I think when I look at the emails that are sent out by the bill team, there are about 100 or so people on it. So the interesting thing, while for me lockdown has basically, I don't think I've ever had a more intense period in my working career. I spent about 20 years in the civil service, so that it's been intense, but I have to say it has been hugely enjoyable. And one of the great things is, I mentioned kind of collaboration within the civil service. What I think the interesting thing here is that collaboration between the executive and Parliament. You know, Parliament is in a bit of a difficult position, between a rock and a hard place. It wants to pass the legislation quickly, but it wants to do the right thing, and it wants to pass good legislation. And government and officials work really closely with the opposition to address any concerns that they had, so they understood things as soon as possible. So for me, you know, that kind of exposure and engagement, you know, with political parties has been really great. And for me, like AGMs, it's quite interesting. In, you know, is this a future model of working? Time will tell. So yeah. If someone had asked me, would you know, if I wasn't in this area and someone said, do you want to work on this emergency bill, I might well have got the barge pole out. But actually, seeing as this is my patch, it's hugely, I think it was in the end quite enjoyable, and it helps an awful lot when you've got a really experienced team around you, and actually the likes of you know, Mike and Peter, you know, working with them, and they've worked closely with David and lots of others in developing the guidance. So this has been collaborative within the civil service, within government, within Parliament and the executive, but also within industry. And it's really great when you can be part of these things, and it's really great to be able to contribute to, obviously devastating stuff going on with respect to people's lives and the economy, but it's great to be able to contribute in some way. So I'll pause there. Otherwise, I'll start to, you know, I could keep going on. Okay,
well, I guess it'd be just you having said that, Nick. I mean, just I hope it's not too presumptuous to speak on behalf of everybody who's on the webinar, but you know, thanks to yourself and colleagues in the civil service, the executive and parliamentarians for getting this through. You know, really helpful, useful measures, much needed for companies at this time. So thank you to all of you.
Indeed.
Perfect. And that's a great note to end on. So a huge thanks to the team from BEIS. So Nick Skates, David Leach, Paul Smith, and Nick Vale. A huge thanks to Mike Metcalf and Peter Swaby for posing some really thoughtful questions and also adding in their experience to those questions posed by the audience. A big thanks to Veronica and R3 for running this and hosting this so beautifully.